Yeah. Which are you? Which year RSA it is? Mr. Nagaraj. Sorry? Deathbed. New respondent or appellant? Who's your opponent? Opponent counsel here. No, government. Mr. Shastri. He's the appellant. Okay, next week on. Give some date. Come for final hearing. Which year pattern? 100. Put it. Put it. Petition ಹಾಕಿದ್ದೀರಾ? Which year? I mean, it's regular course. Take it and post it after 2 weeks or 3 weeks.
Page wise, page number 11. Page 12, number 37 to 39.
ಯಾರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಿ? ಅಪಲೆಂಟ್ಗ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು? Request appellant counsel for appellant released next week. Next week.
13, number 41 to 45. Page 14, number 46. Page 15, number 47 to 53.
One submission, my lord. Serial number 54, my lord. I am for respondent.
Yes.
My lord,
Page
serial
50, number 47 to 53.
My lord, serial number 49, my lord.
If you speak on the mic, he will know you're speaking. Seven, 48. Your appellant. Who's no more? So 2 respondents are there, both are no more. Appeal against R1 is abated as it is. Counsel for the appellant brings to the notice of this court that the second respondent has also died. Yavaga? Did you understand my question? When did he die? Andre after 2 weeks antirani. He seeks time to bring the LRs on record. We list after 2 weeks.
My lord, serial number 49, my lord.
Yes.
I pay for the appellant, my lord. Pay for a week time, my lord.
No. Rejected.
My lord, senior is unwell, my lord.
ಏನ್ರಿ ನೀವು ಮುಂಚೆ ಅದು ಹೇಳಿಲ್ಲ. ಇವಾಗ ರಿಜೆಕ್ಟ್ ಅಂದ್ಮೇಲೆ ಸೀನಿಯರ್ ಇಸ್ ಅನ್ವೆಲ್ ಅಂತೀರಾ. 2007 ಮ್ಯಾಟರ್, the others should go on. There are 4 other persons on record.
Yes, my lord. I will inform them, my lord.
Release tomorrow.
Day after tomorrow, my lord.
Or release day after tomorrow. Date. Request of counsel for appellant.
Matlab.
Page number 16, still number 54 to 58.
At serial number 54, my lord, I pray for 2 weeks time because, my lord, I have suffered, my lord, the ligament fracture of left leg. 3 days back, my lord, that is why, my lord, I am making submission. I am not
Did you
in a
want-
position. My lord, 2 weeks, my lord, I think, my lord, the doctor said that, my lord, it will be recorded within 20 days, sir. But HP Liladhar, my lord, is the other side.
He is here.
Oh, sorry, my lord, sorry.
You can argue online.
My
I will
lord,
hear his argument.
my lord, weeks time, my lord, otherwise, my lord, I could not before, that is
No,
why, my
I'll
lord.
give you 1 week's time. You hear his argument sitting at home.
Please, my lord, I can, my lord, in the next week, if
And
this
for your argument, I will give some time because these are old matters.
please, my lord, if this court, my lord, has grant, my lord, at least 1 week, my lord, I will be prepared within, my lord.
Problem,
I will
you take 1 week, prepare yourself.
Please, my lord.
1 week ಆದ್ಮೇಲೆ only. Learned counsel for the respondent seeks time on the ground of ill health. Same is granted, hence release this matter on
5th September.
5th September. You get ready. What, 5th or 7th?
7th.
7th September. You get ready by then. He will address argument. You can watch
Please,
and then you can take time another week or so.
Please, my lord, please.
PV Chandrasekhar. Request of counsel for respondent. Appellant released next week.
Page
ಯಾವ್ದಮ್ಮ
56.
ನೀವು ಯಾವ್ದು ಕೇಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ. KV ನರಸಿಂಹನ್ ಏನ್ ಮಾಡ್ತೀರಾ? You're only taking time in all matters from the time I have taken this roster after vacation or from 27th. No, he's not arguing even in a single matter. I will make a note that you're only taking adjournments. All are 2007, 6, 8 matters. The cause of pendency is going to be the reason for the council not arguing. I will make a note in the order sheet. Entire blame comes on the judiciary that there's a pendency. I have not seen him arguing even a single case. Learned counsel for the appellant. Who's the other side in this? Seeks time. Release this matter on 4th September.
Page 70, still number 60 to 62. 59 to 62.
Your appellant. The plaintiff or defendant. Learned counsel for the plaintiff submits that the parties have amicably settled their matter. Certain modalities are required to be fulfilled. Once he seeks time, how much time you want? Released on 7th September. Learned counsel for the respondent seeks time, released next week.
Order. Number 1.
How much time you need? Already 10 years or over. 12 years. 13 years. ಇದಕ್ಕೇನು ಪ್ರೊಬೇಟಿಗೆ ಏನು ಟೈಮ್ ಇಲ್ಲನಾ?
We have received the, yesterday, we received the details.
Must satisfy me why the time should be extended and where is a provision for extension of time under the probate rules, under the Section Act. Where is the time? Discretion is with the court after 1 year. Why this discretion should be given to you for even 13 years? Why? What's the reason? Is this probate of will or letters of will? When was the order passed?
80. It is the order.
September 21st. Is it letters of administration or probate of will? Hmm? You don't know. Two thousand 10 alle agide. You are saying 2018. They are even misrepresenting. No. 2008 or 10 alle agirad ನೀವು 18 ಹೇಳ್ತೀರಾ. Yes, Mr. Disa. Where is the provision for extending for more than 13 years for filing accounts? Sattamur, the discretion of the court on an application being filed by the party.
Extension is not provided. Prolongation of the delay. We normally file
An application.
for condoning the delay, whatever the delay is of presenting the account. The actual time starts running 1 year from the date of receipt of the last payment.
2010 ಅಲ್ಲಿ ಮಾಡಿದಾರಲ್ಲ. You satisfy me first how the probate I should grant you permission for extension. No, whatever, even if you file application, that application has to be considered in accordance to what, which law? Which law? The Limitation Act, which is going to come into your aid. Latest judgment which I know of, Isha Bhattacharya says that a Kumbhakarna should not be granted. That is the word used by Supreme Court. And 1987 Katiji's judgment says pragmatic approach. So when you are sleeping, why your application should be granted for extension? Satisfy this court. Otherwise, I'm going to learn counsel for the petitioner seeks time by filing the accounts along with delay application. Release this matter on 11th September. Don't come and stand on the next day like this. Come with do some homework. On details that your client will have. Your client will have the details. Why the bank, of course, will have, but here your client will have. Now everything is computerized. Letter be based anywhere in the country, sir. It's all now computerized. Now I am told it is also simplified. Like earlier, you used to file tax returns, you have to take entire statement of your 10 bank accounts. Now there is something called as AICS or something. If you just type that, you get all your statement in a press of a button, few minutes. All your movables are talking about. Immovable, she will have to get it from the registrar office. Even if she is old, she can give power of attorney. The beneficiary is only going to be some young person, not the. Even if that person gets old, the enjoyment of the fruits by the next generation will be more eager to get it. They are not worried about the old man. File and better additional affidavit. Oh, at least now that the probate is granted, or letters of administration granted, you file whatever is there and say, I will file an additional affidavit later on. Because when keeping all these matters for such a long time. This is 2016 matter. How much time you want? All. Learned counsel for the petitioner seeks time to file accounts. Relist after 4 weeks. 4 weeks.
Three.
What is this settlement report? 10/1/19. 9/9/9 9/9/22. There's some proposal for settlement. The rival claim. You are the rival claimant. There is a connected matter. Hmm. This is probate of will. Will. You're claiming that the will is not correct? So there is rival claim. ಅದನ್ನೇ ಮತ್ತೆ ಹೇಳಿದ್ರಿ rival claim ಅಂದ್ರೆ there's differences of two people trying to claim over the property. That is rival claim. Whether you are rival claimant or he is rival claimant. There's no representation on behalf of petitioner. Learned counsel for respondent is present. We list this matter on 4th September.
Four. Ramachandra.
How much is that? Specifically, not the rate. Maybe not from that.
It be 50,000, let it be 1 rupee. Sir, you have secured an order of probate from this court. You have come before this court, you filed probate petition. You are required to file inventory and accounts. Whether you have property, you sold property, or it is now diminished.
Because of the article, is not available for drinking.
Marty. Because once probate is granted, the next course is you have to file inventory. Even if you dispose, that is the law. Otherwise, you enlighten me if I am wrong. That it is not required to be filed. You show me why it is not required to be filed. Show me, sir, by some law that is immaterial. Learned counsel for the petitioner is present. He seeks 2 weeks' time, same is granted, released after 2 weeks. Please go through the law and tell me. No, if you are right, please convince me. Prove me wrong. I will grant you. This court is not eager to insist you. The law is, if probate says you have to file, you have to file. Even if you dispose it off and nothing comes in your hand, you have to give the inventory and accounts.
File. Still an appellant.
Await service. Await service of notice. Await service of notice. First, you have to comply with those. There are some objections. Huh? Huh? Passover. For what? Yaro. So he is the pleading applicant.
The part of the sticks come under the respondent, from the respondent. That is the seeking here.
He is already impleaded. And he has filed some application.
For the amendment of the cost of security. Two properties. That is the partitions, the respondent partition, the two properties has not included at the time of paying of the security. So, two properties like appellant, property, they are not used to this. They come forward, the application becomes by the time you said that we have no objection. The ownership of this page. One part 2016. But there is nothing cases, still pending. Each may not do, that is the item number 1 on page, being indicated the appeal. Filing the applications were applied, one property was sold, the last page.
Whether IA 1 of 16 is still pending.
The case number Case number 29 not. Right, it's still pending. Meantime, the appellant is not even replied by the report of law that is the sum of the respondent.
You have received copy of IA? Number 1 of IA 1 of 16, have you received?
He has to bring. Two of my applications, 2007 for production of digital documents. One of for amendments, by their point of time. Subsequently, the legal head came on record. There are different set of legal heads that are tribal claims. Therefore, the sample court referred to matter, trial court for adjudication. Therefore, recorded the detailed evidence in the matter. There is the report before the sample court. Based on it, an order came to this month. Both citations of two rival claims, both were rejected. One was claiming based on bill. The other one was claiming that it is adopted for having owned this. So he was claiming it. As against the order of the sample court, the matter is dismissed. Because this is what the order of citation regarding the legal center, they have given. Regarding the adoption, the matter. Now, the individual is not along with the legal. Director, there is no question, I will amend it. Only for production.
Admit agilwa? Or is the matter admitted? The order sheet code. Which IA, which copy? Who was filed that? And you're appearing. Why don't you show the copy? No, even your application, there is some objections. When you are going to comply that? It appears there are several objections raised by the registry with regard to the applications filed by the appellant as well as the respondents. If the objections raised by the registry is not complied in a week's time, list this matter for dismissal. This is not going to be tolerated. That we'll see. Dismissal of the applications, and I will hear the appeal also. See, there are some objections raised by registry. First, you rectify that. Let it come without any objection. But first, you rectify. Once it comes after rectify, then I will hear you on applications and also for admission. Have you filed objections? No objections. All right. Two properties. So you are sailing with the appellant. All right, we'll see whether it is permissible first. You also satisfy this court whether it is permissible now for inclusion. You're in second appeal, you're not in first appeal. Yes, sir, the question is these two properties which you are now trying to impede and bring it into the hodgepodge of the nucleus of joint family property was never a property made in the suit or in the first appeal. How in the second appeal this court can include that? Please satisfy that. Have you seen that? Which is the judgment? Instruction ನೀವು ನಿಧಾನ ತಗೊಳ್ಳಿ. No. Merely because you both are agreeing, this court is not going to allow. You have to first show what is the point of. Maybe, because it is all belonging to you. One of you will get it or all of you may get it. It is in the benefit of all parties. Satisfy the court on legal aspect. Hmm. Navagama deceased R2, order dated 16/6/23. (16/1) 13. How many appellants are there? Huh? R2 also has died. ನೀವ್ಯಾರ್ಗೆ? ನೀವ್ಯಾರ್ಗಮ್ಮ? Who are you appearing? Now R2 died, you don't know, no more appear for R2. You are for R1 now. You have reported the death of R2. Appellant is still. Non taking of steps on the when is it allowed? Is it allowed? The LRs of appellant are brought on record. One, two, and three of 2013. You are not aware. Appellants are already brought on record, LRs, in 2013 itself. You are saying so appellant is dead. When did R2 die? And who has reported that? When did you report it? Huh? Yesterday you came. Learned counsel for the appellant is not present. Counsel for respondent number 1 submits that the respondent number 2 died on 3/3/2018, which was reported on the previous date of hearing. Stop. No steps are taken to bring the LRs of deceased respondent number 2 on record. Hence, the appeal as against respondent number 2 abates. With regard to the appellant, LRs have already been brought on record by an order dated 16/9/2013 in the form of appellants 1A to 1A to C, registry to rectify the notings in the cost list. Oh, nodal. Then our noting prakara no non-taking steps appeal gets dismissed. ಸಂಬಳ ತಗೊಂಡು ಹೋಗೋದು. Just has to see it. Appellant is already on record. So don't make this submission again. Only R2 has died. He is now to bring on R2 on record. Request what? Or file ಮಾಡಬೇಕಮ್ಮ. Or file ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಕೊಡ್ತೀನಿ. If he doesn't file, your rights are going to be affected. You can voluntarily file an application to come on record for LRs because you are appearing for R2. If they come and approach you, and if they don't file, you are at liberty.
Right?
Milords, for the appellant, Milords.
ಯಾವ್ದ್ರಲ್ಲಿ?
Milords, in RSA 19, still I'm right, Milords. Milords, which time will file necessary, do the needful, Milords, file amended cost title.
What is this memo 25/3/21?
Memo filed by the respond number 1 to 3, Milords.
ಏನದು?
Milords, I do not have the copy of it, Milords.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನ್ರಿ?
Appellant, Milords.
ನಿಮಿಷ ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ ಅವರು ಒಂದ್ ನಿಮಿಷ ಕ್ಲೋಸ್ ಆಯ್ತಾ ಅದು? ಫೈನಲ್ ಡಿಗ್ರಿ ಡ್ರಾನ್ ಅಂಡ್ ಕ್ಲೋಸ್ಡ್. ಆಲ್ ಶೇರ್ಸ್ ಆರ್ allotted. There was no stay granted by this court. Question of law is framed. Mr. Appellant Counsel.
Yes, Milords.
Where the question of law is framed.
Milords,
ಗೊತ್ತಿರಲ್ಲ ಅದು. The stage of admission. The FTP is drawn. Final decree is drawn.
Milords, I'm not aware of it, Milords.
If you come to court, you will be aware.
Yes, Milords.
We'll give you copy. You will ಕೂತ್ಕೊಂಡ್ರೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ?
Yes.
He has filed a memo. This memo is filed in 2021. ನೀವು ಅಲ್ಲಿ ಆಫೀಸಲ್ಲಿ ಕೂತ್ಕೊಂಡಿದ್ರೆ ನಿಮ್ಗೆ ಏನು ಅವೇರ್ ಆಗಲ್ಲ.
No, Milords.
Not bothered even to take a copy, a certified copy when your cost list shows. Don't do such kind of practice. Learned Counsel for the respondent has filed a memo dated 25/3/21 reporting that the final decree proceedings is culminated and the respective shares have been allotted. Correct? Close aita no? Counsel for the appellant has not carried out amendment of the cost title. Week's time is granted to do the needful. I'll put forth a submission. Listeners. Rajan. Huh?
Fine.
You want to bring LRs of R1 on record. R1A, Obrena. Who's appearing for R1A? HV Harish. All right. You have any objection? Barkol. Learned Counsel for the appellant has filed 3 applications, IA 1, 2, and 3 of 16. To bring on record the legal representatives of R1, the form of R1A, to condone the delay of 1304 days and to set aside abatement. The notice to R1A has been served and is represented by Learned Counsel Shri Harish HV. Your Shekrappa and Learned Counsel Shekrappa who's present before the court. I peruse the affidavit annexed to these applications. Reasons assigned constitution are bona fide, satisfactory, same is accepted. The applications are allowed. Delay of 1304 days, 4 days is condoned. Abatement is set aside. LR of R1 is permitted to be brought on record as R1A. Counsel for the appellant to carry out amendment, file the amended cost title. A serving copy on the other side. What about R2? R2 also has died, is it? What is this IE number 426? All right, a week's time is granted. If needful done, issue notice to R2 within brackets A and B. Yeah. You are appearing for? You are the employer. KSRTC. What's the suit for? Nobody is given now appointment. When did he die? So in the fight between you both, you have lost the income from the government, which is you ought to have, one of you ought to have been appointed. So you have been taking time from 2016 for service of notice. 2011, you are trying to take out notice. Then what are you doing? What 11 to 14, 11 to 23, you are unable to serve notice. Why should this court show leniency on you if you can't pay? Where is your application? Have you filed any application now to take out? That is restoration. There is an application now. After that, have you filed any application before that? Hmm. Who was represented? Hmm. What is the number of delays in filing recalling application. It's filed in 2016. Recording. Learned counsel for the appellant filed two applications. IA number 1 of 16 and 2 of 16 to recall the order dated 2/11/2016, wherein this court dismissed the appeal against the unserved respondents. Who are those? 1, 2, 3. Who else are there? 4 and 5 is there. So you are not claiming any relief against 1, 2, 3 as also. Against unserved respondents, namely respondents 1 to 3. This application is filed on 15/12/2016. Seeking to condone the delay of 13 days in filing the recall application and to recall the order dated 2/11/2016. Perused the reasons assigned and the cause shown in the affidavit annexed to these applications being to condone the delay and to recall the order of dismissal dated 2/11/2016. Where have you stated that you are having no source of it is stated in the affidavit that the appellant is financially not capable of taking notice through substituted service by newspaper publication due to want of funds and is surviving by meager income, hence was unable to take out notice to the respondents 1 to 3 by way of newspaper publication. Hence, there was a delay in taking out steps to respondent number 1 to 3. However, the application is filed to recall the order. And the guys that they would take out notice to the advocate who represented respondents before the coordinate bench in MFA 11891 of 2011, which is disposed of, wherein the counsel represented the respondent 1 to 3. In view of the above submissions and the reasons assigned in the affidavit, the application deserves to be allowed. Accordingly, it is allowed. Delay of 13 days is condoned. Order dated 2/11/2016 is hereby recalled. And the counsel for the appellant is granted a week's time to. Now, why you are unable to serve through RPAD? Why did it come back as what? MFL ಏನ್ ಹಾಕಿದ್ದಾರೆ? All right, but their address will be there in the MFA. Perfect. So accordingly, applications are allowed. Next para, learned counsel for the appellant is permitted to take out notice on the counsel who had represented respondents 1 to 3 in the MFA number so and so stated here and above, and simultaneously take out notice by way of registered post acknowledgement due and any other mode of service. Yes, you can take out notice to the counsel.
Amen.
Release this matter on first, carry out the amendment and to comply with the objections.
Your Lordship, I appear for the appellant in this matter.
Hmm.
Notice was sent to bring the proposed LRs of respond number 1, that is respond number 1A and B on record. However, it says that there's an acknowledgement having said that it has been received by the other person. Apparently, it has appellant.
You're appearing for R1. What do you want? NY Guru Prakash.
Some other person has to take,
You will have to take out notice once again.
Please, Your Lordship. I had furnished correct address. However, if required, I'll take the steps again.
Your notice has been received by some lady by name Geetamma, but she is not the one going for on behalf of everyone. It is Geetamma who was received. That is here too. Or
It must be some family members.
how to know? You have to file an affidavit.
I will take fresh steps.
8 steps. Learned counsel for the appellant and the counsel for R1 are present. The postal shara of notice sent to R1 within bracket A and B is returned, having been received by a person other than to whom it is addressed. Hence, counsel for appellant to take out fresh steps in respect of R1, A and B. Week's time is granted. If needful, done issue notice. Yes. You file it in the office, the notice will be.
Please, Your Lordship.
Yes. A week's time granted. If needful, done issue notice to us. Yes. 13 is
My
a
lord, number 13, I'm appearing for the appellant in this case. I have paid the process for 3 times, my lord. I will make an application for substituted service.
All right, you file it.
Yes, my lord.
Week's time granted to do the needful. Yes. You have filed memo. Details ಕೊಟ್ಟಿದ್ದೀರಾ ಅದರಲ್ಲಿ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಟೇಕ್ ಇಟ್ ಫ್ರಮ್ ಯು ಗಿವ್ ಅ ಕಾಪಿ ಟು ಹರ್
Date of
14/6
2019.
date of death memo filed on 17/2 learned counsel for the appellant as well as counsel for respondent number 1 are present before the court. Counsel for respondent number 1 reported the death of R1 by filing a memo dated 17/2/2022 by stating that R1 died on 14/6/2019. Till date, no steps are taken to bring the LRs on record. appeal against R1 abates. Others are there. You are appearing for 4, 6, 8 and 11 also. Take out steps.
Familiar?
Two A has died. So 2B, 2A. Two B and C is Viresha. That is what about others? What about A? So totally R2 has 3 LRs, A, B and C. Senate counsel for the appellant is present before the court. In view of death of R2, notices came to be issued to the LRs on the application filed by the appellant IA number 1, 2 and 3 of 2014. The notices have been served to the LRs, namely R2, B and C, whereas notice sent by court to R2A is written with the Shara as died. Full stop. Learned counsel for the appellant has filed a memo stating that the R2B and R2B and C are the LRs of R2A. They be treated as LRs of R2A. Same is accepted and taken on record and accepted. Full stop. Application IA number 1, 2 and 3 of 2014 are perused. Reasons assigned costs shown therein are bona fide and the same is accepted. Accordingly, these 3 applications are allowed. Delay of 386 days in filing LR application is condoned. Abatement set aside. The LRs of R2 are permitted to be brought on record as R2B ABC and the registry under registry and the appellant to show the R2B and C as LRs of R2A in the cost title, carry out the amendment of the cost title and file the amended cost title by serving copy on the other side. As you are permitted to carry out the amendment.
KV Narasimhan.
R1B 1 and 2 ಪರವಾಗಿದೆಯಾ ತಗೊಂಡಿದ್ದಾರಾ Yes, you are appearing for R1 A, C and D. All right. Learned counsel for the appellant and counsel for respondent R1 A, C and D are present. The notice to R1B in bracket 1 and 2 was taken out by way of newspaper publication. In which newspaper? Samyukta Karnataka newspaper dated adella bariyadbeda memo alli
20 March 2020.
20th March 2023. Full stop. R1B1 and 2 ye karidi.
R1B1, Srimati Ganga, R1B2, Shri Gautam.
They have been called out in the open court. There's no representation either by themselves or through a counsel. And the paper publication taken out by way of substitute service is accepted. The respondent R1B within bracket 1 and 2 are deemed as served. The name shall be shown in the cause list. What is next? One of 21. The delay 4. These next para, learned counsel for the appellant has filed 3 applications. 1, 2, and 3 of 2021. Seeking to bring on record the legal representatives of R1 in bracket B. 1 and 2, na? Only B is one. R1B 1 and 2. Stop. I have perused the affidavit annexed to the application, so and so were called. Delay of 492 days condoned, abatement set aside. IA number 3, IA for bringing the LRs of R1B in the form of B1, R1B 1 and 2 is allowed. Counsel for the appellant to carry out the amendment, file the amended cost title by serving copy on the other side. Each time granted to comply with the objections. Learned AG is present. Two weeks time granted to file paper book.
Serial number 19 minutes.
18. Yes.
Serial number 19.
Minutes, I appear for the appellant's minutes. I do the needful within a week's time, minutes.
Learned counsel for the appellant admits that he would do the needful within a week's time. If needful is done, registry to issue notice to R2.
LRs of R2 minutes.
LRs of R2. You have filed application, is it?
Yes, my lords. I filed the application. It was allowed, my lords, on the last date of the
All right. Issue notice on IEs 1, 2, and 3. If needful is done within a week's time.
Obliged.
20.
Non-taking of steps in respect of deceased appellant 1 and R1. Maybe are Nagaraj? 2 to 7. R1 is dead. R1 notice hogi diya LR application. Hakidira. The R1D yaro. R1D Nagamallappa serve agidiyalla without even is filing an application. D Nagamallappa now. He's alive. He's dead. Allah. When he died, you filed memo yavaga. Yes, Jan appellants is there. All right. When did R1 die? Huh?
24/11.
As per order dated 15/7. Charanadu. All right, you are appearing for both the appellants. Then why you don't want to bring the LRs? All right, learned counsel for the appellant and learned counsel for respondent 2 to 7 are present. Counsel for respondent 2 to 7 has reported the death of appellant number 1 and R1. Full stop. The postal sheriff notice to R1 is returned with the sheriff dated 24/11/21 as dead. This court passed an order to take steps in respect of appellant number one and respondent number 1 while order dated 15/7/22. Till date, no steps are taken as against the appellant number 1 and also against respondent number 1. Hence appeal as against appellant number 1 and R1 abates. You're filed. If he doesn't find, then what you have to do? ನೀವು ಹುಡುಕ್ಬೇಕಲ್ಲಿ ಏನೋ ಹಾಕಿದಾರಲ್ಲ 19/2/2017. So you have to go registrar of births and deaths. ಹೌದು. Who has to find out? You are the appellant. Yes, reported the death. So you give a letter to the registrar. He will tell whether such a person is dead when. Death certificate ಕೊಟ್ಟಿದಾರಲ್ರಿ. You will not serve you, madam. These wakalat ceases. Once it ceases, he is reporting death itself. Be thankful he has reported and given you details. 2 weeks time granted to take necessary steps. Counsel for appellant is present. ಒಬ್ಬರೇನೇ ಇರೋದು ಮತ್ತೆ he will not have interest if nobody comes to him. ಎಲ್ಲಾರ್ಸ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಇಂಟ್ರೆಸ್ಟ್ ಇರುತ್ತೆ ಅಡ್ವೊಕೇಟ್ಗೆ? ನೀವು ಬರ್ತೀರಾ ನಿಮ್ ಕ್ಲೈಂಟ್ ಬರ್ದಿದ್ರೆ? ಅಡ್ವೊಕೇಟ್ ಹೌ ಯು ಕ್ಯಾನ್ ಬ್ಲೇಮ್ ದ ಅಡ್ವೊಕೇಟ್? ಅವ್ರು ಕೊಟ್ಟಿರೋದೇ ಜಾಸ್ತಿ ನಿಮ್ಗೆ. ಕಾಪಿ ನಿಮ್ ಮನೇಲಿ ಬಂದು ಕೊಡ್ಬೇಕು ಅವ್ರು. ನೀವು ನೋಡ್ಬೇಕಿಲ್ಲಿ. You should see the records. Take it from her and see at 1:30. This is a memo file. The counsel for respondent R1 antidyala. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ respondent? Counsel for respondent has filed a memo dated
12/2020
reporting the death of sole respondent on
19/2017.
along with death certificate. Till date, no steps are taken to bring the LRs on record. Appeal abates against the respondent. Appeal abates. File application. On taking of steps, ceased R2. ಯಾವಾಗ ಸತ್ತಿರೋದು? Your appellant. ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ? ಒಬ್ರೆ. You filed memo for retirement. You come on record. What's your name? So Uday Kumar has given NOC. So his name can be deleted. Retirement. Learned counsel for the appellant Shri Uday Kumar G. You're ಬಂದಿದ್ದೀರಾ? Has filed a memo for retirement. Is a memo for retirement. Retirement. So he was also along with you. Appellant Uday Kumar advocate was along with you. NSC ಕೊಟ್ರ ಗೊತ್ತಿಲ್ಲ. ನಿನ್ ತಲೆ ಆಡ್ಸದ್ ಬಿಟ್ಟು ಏನಾರ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ? ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರ. Learned counsel Uday Kumar G has filed memo of retirement in view of subsequent wakalat being filed by learned counsel S Nagaraj for appellant A1 within bracket A. Counsel Shri Uday Kumar G is permitted to retire registry to delete his name from the cost list. Full stop. How many respondents are there? By the order dated 17/3/23, this court granted time to take steps to bring the legal representatives on record of respondent R2, who died on 2/3/2022. Till date, no steps are taken to bring the LRs of R2 on record. Hence, appeal against R2 abates.
For respondent number 1, my lordship.
Phone number?
23rd serial number for respondent number 1.
Complaint ಇದೆಯಲ್ರಿ?
Appellant has to comply of this objection.
LR application ಬಂದಿಲ್ವಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
All right. A week's time granted to comply at request of counsel for appellant. ಯಾರು? You are in the office of Harish Kumar? Proxy counsel. Learned counsel for the counsel representing appellant seeks time released next week.
The application for honoration of the application was not given. Here you are used to for the good topic for only year for
Now everything they want full cost.
the application, they should notice to the part to
Or copy code. Let's see what is the objection other than Adundena. So in two applications, full cost title is there. ಇದೆಯಾ? ಇನ್ನೇನು ಅಡಿಷನಲ್ ವರ್ಕ್ ನಿಮಗೆ ಪ್ರಿಂಟ್ ಔಟ್ ತಗೋಬೇಕು ಅಷ್ಟೇ ತಾನೆ. Correct, but what to do now because of your request or the rules committee has made such a rule, you have to follow the rule. 27? ಅವ್ರಿಗೇನೆ ಹಾಕಿರೋದು ಇದು. How you can? Unless his client comes to him, how you can? Learn the office of objections raised by the registry or one of the applications with regard to full cost title is overruled for the reason that in the other application filed by the appellant to bring LRs of deceased R2, full cost title is filed. Full stop. Issue notice on IA 1 to 3 of 2023. 1 of 22. 1 of 22 and 23 and 1, 2 and 3 of 22. What is this impleading application?
It's filed with you. Asking when I find objection to that. He is not a necessary party, it is a necessary not proper party. Someone because not the appeal.
Who has filed it?
The one Bhattacharya has filed. Claiming that Lord immediate. Well, now.
Who's the advocate? He wants to come on record as? There's no representation on behalf of the pleading applicant. I relist after service of notice. Counsel for respondents are 1 to 10 is present before the court.
I also received the data of R1 and R9.
Yeah.
I had contacted the local advocate to give to interrogate the party. Also, I contacted some of the other parties. They are not come. No, the appeal has awaited. Lot if the appeal has awaited. If they want to find lot and take steps, they are the
R1 and 9. Yavaga, when did you get by?
He like long back now.
Of R9, 9
9-3 now. Good. Counsel for appellant is present. He's granted a week's time to take to do the needful. If needful done, registry to issue notice to R4 and R5.
No,
They're not taking steps for 4 and 5. This court cannot do that. This court, because you are frustrated with your client. Then you file memo, sir. How can this court say? No. Don't do that. MLA ಹಾಕ್ಬಿಡ್ತಾರೆ ಆಮೇಲೆ. I granted you 1 week's time for 4 and 5 with regard to respondent number 1 and R9. The postal shara is returned dated 11/3/19 and 9/3/19 respectively, showing them to be dead. Till date, no steps are taken to bring the LRs on record of R1 and R9. Hence, appeal against R1 and 9 abates. Kalisi, send a letter. It's a procedure we have to follow. Otherwise, you will incur the wrath of the the party. He will file against you in the bar council. Right, all that. Follow the procedure. Send a retirement. Fish. Sole appellant, huh? Tied on 20. 100 days. 353 days ಅಂತ ಇದೆ. So IA number 1, 2, and 3, na? So your file wakalat for A1, A, Babre, LR. In Nimesarina. N Gurumurthy. So other two are appearing along with you, Venkatesh and Sundaresh. No, you want their name to be retained. Learned counsel for the appellant is present. Has filed an application to bring the legal representatives of appellant A1 within bracket A. Babre na appellant, A1A. There's a delay of 100 days in filing the application. Wakalat has been filed by the learned counsel for the LR of A1, the form of A1A. Peruse the affidavit annexed to the application. Also, delay of 100 days condoned, abatement set aside, application allowed. Yes, what about the others? Notice of Beka. Issue notice on IA number 3, 4, and 5, and 6. 3 Allah, 4, 5, and 6. 4, 5, and 6.
Take the Sheffield.
A2 of 23. Same application. Learned counsel does not press IA number 2 of 2023. Accordingly, IA 2 of 23 is dismissed as not pressed. Yes. What? Huh? Paper book hakilva. 2 weeks time granted to file paper book. IA number 1 of 23 is allowed. List this matter on 21st September. 21st September. Argument address ಮಾಡ್ತೀರಾ main ಏನು admission ಗೆ ಬರಬೇಕಾ ಏನಿದೆ hearing ಬರಬೇಕಾ IA 1 of 23 allowed just on 20th September. You're in a hurry. It's not there. This month ಅನ್ಕೊಂಡ್ರಾ ಇಲ್ಲಮ್ಮ ಇವತ್ತು ಡೇಟ್ you're running behind schedule. ಇವತ್ತು ಏನ್ ಡೇಟ್ ಗೊತ್ತಿದ್ಯಾ ನೆಕ್ಸ್ಟ್ yes, you have any objection? Return of original ಮಾಡೋಣ. The counsel for the appellant has filed an application under Order 9 Rule 39 Rule 9. ಏನ್ರಿ ಇದು? 39 Rule 9. Order 13 Rule 9 for return of original documents only exhibit D1 and D2 marked in original suit 168 of 2001, which is the file is here now. Originals are here, which is filed before which the records of which are before this court. I'll stop. Objections to the said application is not filed by the learned counsel for respondent. However, he does not have serious objection in return of the original documents if certified copies of the same are filed before this court. Counsel for the appellant submits that he has filed the certified copies of the original documents, namely Exhibit D1 and D2. View of the same, IA number so and so is allowed. 1 of 22 is allowed. Registry to return the original document, namely Exhibit D1 and D2, marked in OS 168 of 2001 to the appellant. Upon securing the certified copy of the same, the original document shall be returned upon proper verification. For appellant along certified copy of it. Return. That is producing certified copy.
Copies and taking return of work.
The memo is disposed of. Rendra Patil. Notice of Bekena. R1 1 to 7. Kavita HC. You are undertaking to file. So this application can be allowed. When did that R1 die? 1910. So it's on time. Counsel for the appellant and the counsel for respondent 1, R1 within bracket 1 to 7 are present. Application IA 1 of 20 is filed to bring on record LRs of R1 in the form of R1 within brackets 1 to 7. Notices served and learned counsel Kavita HC undertakes to file wakalat on behalf of R1 within bracket 1 to 7. Being satisfied with the reasons assigned and the cost shown, IA1 is allowed. Accordingly, the LRs of R1 are permitted to be brought on record as R1 in bracket 1 to 7. Appellant counsel to carry out the amendment of the cost title file copy of by serving a copy on the other side. ಹನುಮಂತರ ಏನ್ರಿ ಇದು ಒಂದು ಫುಲ್ ಪೇಜ್ ಇದೆಯಲ್ಲ ಇದು 1896 days in recalling order 8713. You have woken up now. ಯಾವಾಗ ನೀವು ಫೈಲ್ ಮಾಡಿದ ಅಪ್ಲಿಕೇಶನ್ 18. How many days delay? How many years delay? 5 years. ಏನಿದೆ ಇಂಜಂಕ್ಷನ್ ಸೂಟ? ನೀವು ಯಾರಿಗೆ? Defendant. Suit is? So you are plaintiff. Defendant. Plaintiff has filed the appeal. You are respondent here. In declaration, ownership. There's no representation on behalf of appellant. Learned counsel for respondent is present. Which respondent are you? No, you are representing whom? A number? So you have filed application to come on record. You are also equally late. Relist next week. I think he is not interested. Next week.
33.
ಇನ್ನು ಹೈಯೇ ಅಲ್ಲಿ appeal. What is the reason? Further orders. R3 is dismissed for default. What is the delay of how many days? 214. The counsel for the appellant is present, no representation on behalf of respondents. IA number 1 of 14 is filed by the counsel for appellant, seeking to condone the delay of 214 days in filing the appeal. Objections to this application is not filed. I peruse the affidavit annexed to the application, being satisfied with the reasons assigned in para number 5 of the affidavit. The application deserves to be allowed. Accordingly, it is allowed. Delay of 214 days in filing the appeal is condoned. Released after 2 weeks for admission. They are appellant 1 Satidara. You have filed wakalat? There is no representation on behalf of appellant. Counsel for respondent R1 to 12 is present. Will be released for 2 weeks. This is the WP. You are again for university. This is cautious. Correct, but how you are going to sustain that order? Your submission, which you have made. No, are you disputing what he has stated, that there was a transaction between the writ petitioner and the third party? Huh? Could you have the application? Could you? No, he has filed all those documents. Huh? Nothing stops you from taking the copy from here and looking at it. The documents filed. Seeing those documents. What is it? Ah.
I'm for the appellant in this case, Your Lordship.
Yes.
Your Lordship, at serial number 34, I am for the appellant. Your Lordship, I have filed the legal aid application, Your Lordship. That on 10/3/2021, I have filed the legal aid application. That should be allowed, Your Lordship. It is in time, Your Lordship. In time alide.
New York.
I am for the appellant, Your Lordship. Appellant is no more.
What were you doing when the case was called?
Your Lordship,
Where is your video?
I'm on the just a minute, video.
In date
Yes, Your Lordship. I am now in the.
All right, you come after 2 weeks. It's urgent for 2 weeks. Next.
Okay. Yes, Your Lordship. Obliged,
Yes.
much obliged. Leave.
You have not been given copy. Learned counsel for the petitioner is present before the court. So also the counsel for respondent number 1 and learned AGA for R2. There's no representation on behalf of the proposed respondent number 3, who was secured an interim order from this court on whose request and application, an interim order came to be passed by this court dated 22/8/2023, not to give effect. Order 11/7. Order already. Not to give effect ಯಾವಾಗ ಮಾಡಿರೋದು? Eleven seven is not to dispose of. ಏನ್ ಬರ್ತೀವಿ? 22 ಅಲ್ಲ, on 11/7/2023, directing respondents 1 and 2 not to implement the order dated 11/4/2023, despite sufficient opportunity being given. It appears that the proposed respondent number 3 is not interested in the matter. Hence, release this matter tomorrow. We'll have it tomorrow. 29th. 30th. What you have to also say. No, that's okay, but now with regard to the allegations made by the proposed respondent number 3. For the university, you should know who's running, whether he's running or XY is running. You better secure the file, otherwise you are also going to be in trouble for collusion with him. Have you read the order passed by me? Then taking it very lightly. Friday. All right. List on Friday. First. Find out. That is the allegation made by the proposed respondent against you. But you are aware, he has sold the property and the nursing school, nursing school to him. He's running it. After selling the nursing school, you, the original person, comes before the court and says change of user ID. Once the user ID is changed, how that person will run the school? Go through it. Go through it. That is his contention. You have sold it, you have taken money. That's his contention. Next. In his head up in? ಬನ್ನಿ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ ಪೂರ ದಿನ ಹೇಳ್ದಪ್ಪ. Yes, madam, what do you say? Your rival claimant. Correct. Is there rival claim? So he has filed for revocation. He has filed for revocation of the, which was granted in your favor. So already the Australian court has granted probate of what properties? All right, that must be only for the properties. That you have sought. Granted. Grant. All right, so that he's trying to revoke. That is permissible.
Because ancillary probate cannot be revoked after the original was of the song. Unless and until the original probate is not fatted, they cannot practice an ancillary. Moreover, he has no notice that because he is confident of he does not have opinion and in the probate proceedings. He is a complete stranger. It is for that reason that I filed a declaration to the city civil court which came to be partly received.
All right, when do you want to argue, Mr.? Release this matter on first. Release matter on 5th at request of counsel for at request of the counsel Sri Hari TV. You are appearing for Sri Hari. Learned counsel Srimati Ranjana Iyer is present before the court. If the learned counsel doesn't proceed to argue the matter on the next date of hearing, counsel for the respondent, counsel Srimati Ranjana Iyer will be heard in the matter. Now, any objection? 7. When she says there are 7 objections, you want to say only court fee, what to do?
Yes.
You rectify the objections raised after restoration. Whereas the conditional order passed by this court to rectify. No. All right, but this court has not passed any conditional order. So we'll grant him. All right, we'll grant him 1 week's time. If he doesn't pay, let it come up for dismissal. Learned counsel for the appellant and learned counsel for respondent are present before the court. While order dated 10/8/2023, this court allowed the application Oh, this is that matter in which there were some errors. Technical errors. Due to this court accepted the cost of rupees 5,000 paid by the counsel for appellant and the appeals earlier which were restored was ordered to be restored, notwithstanding the fact that in one of the matter there was an error. However, in view of the restoration of the appeals and there being objections raised by the registry in RSA 1399 of 2011, counsel for the appellant to rectify the objection within a week's time, failing which list this matter for dismissal on 11th September. If you don't rectify, I'm going to dismiss it on that day. To comply objections within a week. Within that 11th, within a week, within that day, within the next date of hearing. Jai Shri. No representation on behalf of appellant and the respondent. Relist after 2 weeks.
That I appear for petitioner appellant. That it is the plaintiff's appeal. That the plaintiff has filed a suit or injunction that in respect of the 27 guntas. In survey number 76/6. That the trial court on 9/12/1993 decreed the suit in favor of the plaintiff. Against which, my lord, that is the 1/8/1997, the date, my lord, my mistake. 1/8/1997, it was decreed in favor of the plaintiff.
You are appearing for appellant in both the cases?
Plaintiff appellant, my lord.
Both cases?
Yes, both the cases.
From same appellant?
Common order, my lord. After the decree, my lord, defendant.
How many appellants are there?
That appellants, there are 5 appellants in one case.
ಯಾವುದು ನಿಮ್ದು RHA number, serial number ಯಾವುದು? Narayan Reddy ಅಲ್ಲ?
Please, 40.
Serial number 40 and 40.1.
House.
Other list ಏನಿದೆ? ಇರಪ್ಪ ಇದಾರಾ? OS number ಏನಾದ್ರು? How many suits were filed?
That originally, my lord, 4 suits have been filed. It is a judgment. It is there, my lord, Annex A. You last kindly see. Page 12, typed page 68, my lord, typed K page, judgment and decree.
In the connected matter,
Yes, my lord.
the appellant has died.
Yes, subsequently, the LR application has been filed.
Is it allowed?
Yes, my lord.
When it is allowed?
Yes, my lord.
The application allowed agilwalri.
I verify ಮಾಡ್ತೀನಿ so I say because the separate file is there. One file it has picked up.
No, first your application has to be
Exactly
allowed.
filed and it is come up before the court. I am not aware.
No, both the cases are listed today.
ಆಗಿದೆ ಸುಮ್ಮನೆ because other files it is not available. Last time also I have submitted.
Then you do not want to argue 40.1.
I will argue.
ಯಾವಾಗ?
Well, I will argue. In the first case, you will last kindly see.
What is there to see in first case when the second case the appellant is dead?
It is a common order, my lord. Earlier, my lord, the dishonorable court, after setting aside the judgment and decree of the first appellate court, remanded back to the trial court, the lower appellate court, for reconsider the same by adducing the evidence, additional evidence. Let before the lower appellate court, the parties have adduced the additional evidence. The judgment again, it is reverse the finding of the trial court. Against that order, my lord, I have referred this appeal in the second round. You will also kindly see the first order passed by this honorable court in connected case RSA 341 of 2005. It is decided on 25 May 2011. The operative portion I will read, my lord. You will also kindly see.
Narayan Reddy.
Please, my lord.
You are arguing first time in the High Court. You are arguing first time in the High Court.
No, sorry, my lord.
I'm telling you that in the connected appeal filed by you, appellant is dead, you filed application. Tell us the record of Sarbarda.
That is not.
Before that, you want to argue the main matter. If it is your choice, you want to argue the first matter, I will hear you.
I will that application also.
Dealing this matter, you argue the first matter. No problem.
I will ascertain both the applications. That is only.
Application ascertainment appellant is dead. You have filed 3 applications to bring on record.
Yes, file matter. Adu ಸದ್ಯಕ್ಕೆ ನನ್ನ ಹತ್ರ ಇಲ್ಲ. I will.
ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ?
ಒಂದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ನಾನು ಅದನ್ನ ಫೈಂಡ್ ಔಟ್ ಮಾಡ್ತೀನಿ. The office itself.
Nothing much you have to do. You have to only. The application will have to be allowed, but that also you don't have with you. Procedural formalities have to be completed before hearing you.
Yes.
Who's your opponent?
Somebody is.
Somebody there. Somebody only will be there.
Is some Jaiprakash.
Why is the delay of 5 years in filing the application? If you argue the application on the next, it secures the file.
Please.
Learned counsel. For the appellant is present. No representation on behalf of respondent. Release this matter on 7th is okay.
Please, please.
Released on 7th September.
41.
Want to withdraw?
Yes.
Okay, learned counsel for appellant and respondent are present. Released on 31st or 1st. All right, released on 4th September. Mr. Mahesh. Your plaintiff. So initially it was decreed, set aside in the no contest. Okay, anyway, that was ex parte.
They are in models. They are in. They are not interested in. Not for the remainder of it. Leave them in our case. Particularly, they are part for the remainder of it.
There is the appeal filed. You have the appeal memo. First appeal court. Kodima. What is the prayer? So without there being any evidence, written statement, now the first appellate court has set aside. On the basis of documents. Let us see the order. Hmm. Yes, I have. Yes, please. That's on date of the suit. What is the relationship of Puttaswamy with the appellant in the first appeal, that is your defendant in your suit, Yogendra? They are the children of Puttaswamy. But I asked you, what is the relationship? No, it is your own case. See, when you file the suit, your case is that the entire entries are standing in the name of one Puttaswamy. The defendants are none other than children of Puttaswamy. Nothing. That is what is stated here in the first appeal. Read further. What is the document you have produced to show that this property belongs to you? The revenue records describe your title. That you have to prove, alva.
And also, P13 and 14.
So what is exhibit P9? What does it describe and show? How they got it? How they got it? How they got it? Again, his ancestors. Decades ago, somebody has to get it by some method. Grant. Investigated, you have to produce it to prove ownership.
It doesn't matter. What happened? It is goodness instead of entering the 366 market, it is 366 has been declared. Just because of entering the name, I have to produce to endorse the authorities market, which will be 19 and 14.
What is the measurement of the land? Survey number? Who's in possession now?
They have not taken any, even in the appeal market, they have not stated so. In possession of
Now, the fundamentals is when you approach the court, you have to prove your case. Prove madidare. What is undisputed? Because he never participated. Even if he doesn't participate. No. Even if he doesn't participate, if he's ex parte, court has to see whether how your owner, maximum it can grant you possession, permanent injunction if you prove that you are in possession. Even that you have not proved. No, it is your own case that after partition, his father's name is shown. Then how you can get title? Sir, you are only sticking on to your entries in revenue records. How you can become owner on the basis of revenue records? How you will get, what is the document you have shown? What do you have, service kit? What is P9? ಯಾರು ಸೇರಿದೆ ಇದು? Whose name is there in this?
My grandfather.
ಯಾವಾಗ? Because your own statement in the plaint is that even after partition, they are in possession. I mean, their rentries are in their name. That is dismissed, which you filed before the Tahsildar. No, you went before AC. That is dismissed. Whether AC has allowed your petition. So all the revenue courts, 3 courts have rejected your claim. AC has rejected. How the civil court can correct such entries? How the civil court has jurisdiction under 132 of the Land Reforms Act? These mutation entries, revenue entries are to be corrected. No civil court will have jurisdiction. There's a non-abstention clause. What do you mean? To that land reform, which is that provision? Land reforms. Para number? Print page number 10. From top. Have you produced any piece of document to show Then pretty much. Okay. 32. Yeah. Duty. Right. There is a question of civil court getting jurisdiction. But you're not gone before the civil court for rectification or agreed by the orders, or you could have come in writ. You have gone before the civil court for declaration of your title. When already there is an order against you by the revenue courts with regard to the name entries in the mutation entries. And even you plead in this suit that the names are of the father of the defendant is shown. Wrongly shown on mele, you have to set it right. How? All right. All right. Now, after the first appellate court deciding the suit against you, have you placed any material here? Sir, again, you are going back. You have filed a suit for declaration of title. The 2014 matter now, after questioning by this court, you are saying you're going to produce. What is wrong with the judgment of the first appellate court? What evidence? You have not produced any material. You have admitted yourself.
And particularly to show that it is wrongly entered the name of
You filed the suit for what? What you have to produce and what you have to prove. So ancestral property title deed illa andre heng barutte nimage? Heng barbeku? According to you, it has come by partition. Partition banmege how they got it? No, that would sustain if they have not come before the court or you had not pleaded that it is in their names. Even in your pleadings, you say it is in his name. How you have to go about that wrong rectification?
They are not mentioned any rotation in the article.
ಸರ್ವೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಇದೆಯಾ ನಿಮ್ದು ಅಂತ ಪ್ರಾಪರ್ಟಿ? ನೆಕ್ಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಏನದು? ವಾಟ್ ಇಸ್ ದಟ್? No mutation is entered in the name of? And why did you go before the AC and DC for correction? If no mutation is entered, why did you go before the AC and DC?
ಏನು ಬೋರ್ಡ್ ಸರ್ವೆ ನಂಬರ್ 350 ನಂಬರ್ ಇರುವುದಿಲ್ಲ. ಅದರಿಂದ ನೀವು ಕೋರುವ ಎಲ್ಲಾ there is no any MR entered in. There is no we cannot display. Not there enough.
Mugisli Rapa or Mugisli. What is this P16 is your partition? Where how do you get the property in that partition? Where is it explained how you got your ancestors got the property? No explanation there also. Where is the survey number mentioned here? Delhi. Okay. Yes. So. Do you have any document to show that your ancestors owned this property? That is for you to ask, not for the court. How do you get the property? Are you having any document of title? ಏನದು? So you are also equal like him only. Let it be 47. What about your client? What he says? All right, both of you produce documents. Is it not your duty to place it? Engre argument ಮಾಡ್ತೀರಾ ಮತ್ತೆ? The first appellate court has set aside your decree. ಅವ್ರ ಹತ್ರನೂ ಏನಿಲ್ಲ. Your suit is dismissed for your own asking. Learned counsel for the appellant as well as learned counsel for the respondent to place material documents before this court to show their ownership by way of title. How much time you want? 2 weeks time granted. Both of you to produce.
Lady who definitely to my Lord, is Raj and who married his my Lord Sri Salam on 10/5/1980
Suit for what?
for my Lord Narration. Because painting is the suspect, defendant is the right, and not the marriage solemnized in the year 10/5/1980. After the marriage, he and he went to North Canada. The Lord, there is no good opinion in respect to the Lord. Ultimately, the Lord, my husband, the state has purchased property in question. That is the Lord 3 hectares 12 Luta. Situated at the Lord Patandur Agra village, located at Godi Pasandara, Whitefield, Bajapur, Bengaluru. That is land present in the Lord 3 hectares 12 Luta.
Who purchased? Plaintiff purchased.
Plaintiff purchased the name of the wife. It was immediately I went to Canada. It's here. So that I have nothing. But I legally wedded by. That is on April 6, 1981. As per the Lord, same.
3 acres 12 guntas.
Yes, ma'am. That is survey number 109 or 1, vote survey number 32. After that, my Lord, that is total state consideration of 35,000. This is the year 1981. After that, my Lord, the she also came and joined to me in Canada. And my Lord, because of difference opinion in the life, after the delivery to children, we have my Lord approached the court of the independent court of the Canada and obtained the Lord the decree of divorce.
You filed.
Yes. He and the both of my Lord filed there
Together.
Canada independent court. requested her to give my lord property back, which I have purchased in her name. This is the only earned property which I like. So that please give back that property. She has refused. Then my lord, without any alternative remedy, came down to India, right, because that's so. That is my lord, equally my lord, instituted before the London Trial Court, that is 1993, against my wife. And number sufficient before the Honorable Court, my lord. The London Trial Court, my lord, based on the judgment which has been related by the defendant with respect to the Benami transaction, that is, my lord, the prohibition of Benami property transaction act. Same my lord executed 10/5/1980.
And five?
1980.
Ah.
In the name of my wife. They have my lord applied the law, that is section 3(4) under the prohibition of Benami property transaction act. The lordship may kindly come to running page number 45. The discussion which has been made by the learned trial court. For the proof towards the my lord,
What ಇವಾಗಲೇ ಮಾಡಿ.
proof towards the payment is according to the my lord document, exhibit P7, there is a proof, and see also here. I have decided money about the total. It is rupees 52,000. It has discussed by the government by however, the government trial court, the suit is my lord time also, so that it cannot be considered accordingly my lord prayer rejected. Then my lord again my lord I went to the question honorable question. Second time, respect to the payment, it comes to question. Valid balance, how it was about dissolved after the block of fruits in Canada only, and about they are the citizens whether at Canada state. However, the learned constituted court only one on that. It is bar by limited. So when title dispute with respect to property question, when it is why? Because the learned transport the I have paid my hard money with respect to subsidiary property. Either in my name of the underlying daughter or mine. So we are not concerned with the tenant. Wife and my lord unmarried daughters are not tenant. Moreover, my lord, the property was purchased in the year 1980. This act is came to the force my lord in the year 1988. So that my lord, it is a prospective effect. It should not be considered as a retrospective effect. Even if it is for a sake of argument of the defendant for movement, it is a retrospective effect. And my wife is tenant. Wife is a not legally wedded wife. But in the manner I have purchased in her name because as on the date of the purchasing property, I was for livelihood to protect my wife. I have went to the Canada state and earned money. Accordingly, send the money to her account and she has purchased in her name. Absolutely, my lord, is admitted that there is no dispute either in the trial court or in the No, my lord. The Northern Trial Court has not framed about my lord the issue is concerned whether the property is my lord agricultural land or not. RTC has not produced. However, the defendant has produced the RTC as per my lord the answer which has given by the Northern Trial Court to the issue number 50 concerned it is an agricultural land. Then my lord, the London Trial Court only on the issue is concerned, I will permitted to read. The lordship may kindly permit the word at 30 page number This stated case number 19 of the London Trial Court order. That is judgment. Paragraph number 24, paragraph number 53.
You continue in the afternoon. So now both parties have separated by virtue of divorce. Yeah. What is the question of law framed? Which is coming for admission. Because we'll see what is the question of law he's going to bring out in the afternoon. No problem. A colleague, somebody can be here. First, he has to satisfy this court. How, what, and what he has. Huh? ನೀವು ಈ ಕೇಸಲ್ಲಿ ಇದ್ದೀರಾ? You got the judgments? When? No, today if I'm going to decide in the afternoon, tomorrow in ಮಾಡ್ತೀರಾ ನೀವು? He's also ready in the afternoon. Even if he's not ready, you have to be ready. If this court is not satisfied with you, that's the question of him arguing for framing question of court is not going to look into facts. Very crucial. Question of law frame ಮಾಡುವಾಗ again facts crucial. ಅವ್ರೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ನೀವು ಗಂಡ ಹೆಂಡತಿ ಆಲ್ರೆಡಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಲ್ಲಿ ಕೆನಡಾ ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ ಡೈವೋರ್ಸ್, ಅವ್ರೇನ್ ಮಾಡೋದು ಪಾಪ. Yes. 16. 60. All right. Serial number 60 at request of counsel for appellant released next week. Serial number 43. Heard learned counsel Pawan Chandra Shetty. Learned counsel for the respondent 6 time. When do you want? First, released on 1st September. ಯಾವುದು? 46. ಅಬೇಟ್ ಆಗಿದೆಯಲ್ಲ, ಯಾರು ಅಪೆಲೆಂಟ್? ಅಪೆಲೆಂಟ್ 1 ಇದಾರಲ್ಲ. So that appeal will continue. Then bring you, if he doesn't bring this. All. No. But I am not giving adjournment. You argue the matter. It is abated. On that ground, this court cannot grant you time. Right? 2006. No. You argue, Rupesha. Huh? Idara, Rupesh.
My lord, I got throat infection, my lord. 10 days time, my lord.
2006 matter time ಕೇಳ್ತಿರಲ್ಲ.
10 days, my lord, I will argue.
ಯಾವ್ದ್ರಲ್ಲಿ?
44, my lord.
Have any objection? You are not ready, that means. Learned counsel for the appellant seeks time on the ground of ill health. 10 days time is granted, released after 10 days. Setting cancel ಆಗಿದೆ. ಯಾರು ಕಾಣಿಸ್ತಾ ಹಾ ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಇಲ್ಲಲ್ಲ. $45.1. So first matter you are appellant. Second matter you are appellant. So both are arising out of the same suit. Well, who are you in the trial court? You? Second. So 1, 2 and 7 are before this court in appeal.
We are in appeal. If divergence finding which is being recorded by the
What is this non-amendment?
we have another.
R7A. 3-1. Has not carried out the amendment of the cost ID. ನೀವು ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ನಮ್ಮ ಅಪೀಲ್ ಮೆಮೋ ಅಲ್ಲಿ ನೋಡಿ 7A ಮಾಡಿದಾರ. ಇಲ್ಲ, ಇಟ್ಸ್ ಈಸ್ಟ್ 7A. ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ, ಅದನ್ನ ಹೇಳಿದಾರ ಅನ್ನೋದು. Just a matter of ಅದೊಂದು ಮಾಡ್ಬೇಕಷ್ಟೆ. Only objection of plans. What about second matter, additional ground, substantial question of law? You want to start? ಯಾರು? MS Rajendra for R1, Mahantesh Hosmat for R2 and 3. Idra. All right, you can comments, we'll see. Anybody else is there? No, both parties. No, I'm just checking if anybody else is there, two parties, I can hear it and pass over your matter. Or I can hear you. In yaudide my matter, only 3 more matters are there. You start, New Year again. Seven. Both of you are ready? How much time you'll take? Anyway. So I'll call your matter after that. We'll wait. Meanwhile, if they come. It's not given for steps. It is just adjourned. R2 has died when? R2 died when? Give your give. Also, so you submit on the next time. Now that it is adjourned, you can't do anything. Your friend, they only take behind your back. Normally, we expect them to inform. Madadilla. On the next date, you submit when he's there. So. Manjunda Gowda, na? Anand. Yes. Next week, ಮಾಡ್ತೀರಾ ಇರಲ್ಲ ಇವರು ಶೇಖರ ನಿಮ್ಮ ಹೆಸರು ನೀವು ಶೇಖರ ಯು ಆರ್ ನಾಟ್ ರೆಡಿ Learned Council Sri PK Manjunath seeks time, whereas Learned Council LS Shekhar, correspondent is ready to go on with the matter. At request of Appellant Council, released on. ಅದೇ ಡೇಟ್ ಕೊಡೋಣ ಲಿಸ್ಟ್ ಆನ್ 7th 7ನೇ ತಾರೀಕು ಮಾಡ್ತೀರಾ 7th Plaintiff's second appeal. So concurrent finding of dismissal of the suit. So you're in appeal. So nothing is there. ಇದೇನಕ್ಕೆ No, you narrate the facts. Seven. Mortgage deed ಯಾರು ಕೊಟ್ಟ One to four. They are in sisters, sir. Poor Sharif. Children of Tiptur Pushar ಅಂತ ಇದಲ್ರಿ ಪುಷಾರ್ ಶರೀಫ್ ಗಫೂರ್ ಶರೀಫ್ ಅಂತೀರಾ ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಪುಷಾರ್
But if you create 1 kg, it is 3 kg.
So what is the relationship of plaintiff and defendant? No relation. So Rasul Khan, who's the husband of plaintiff, he has executed the mortgage deed in favor of the father of defendants number 1, 2, and 3. What is his name? ಆಮೇಲೆ dismissed. ಒಂದ್ಸರಿ ಓದ್ಬಿಡಿ, we'll see. Read the judgment of the trial court. Paper book ಕೊಡಿಮ. See, if the Rasul Khan has given mortgage deed to the father of the defendant 1, 2, 3, their name is known as Tushar Sharif Sahab. Illide Gafar Sharif. See in your suit which you have filed, what is described? Dispute in the ye ತಪ್ಪು ಯಾಕೆ ಮಾಡಿದ್ದೀರಾ? That is the name of Gafar Sharif as the father of the defendants 1, 2, 3. All right, read page 22. What about 3? Turn off. ಕನ್ನಡದಲ್ಲಿದೆಯಾ? ನೀವು ಟೈಪ್ ಮಾಡಿರೋ ತಪ್ಪು ಮಾಡಿದೆ. Plaint is in which language? ಓದು. Yes. Yes. Hmm. Hmm. Come to para 9. ಅದು ಬೇಕಾಗಿಲ್ಲ ಬಂದೈತಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ para 10 ಇದ್ದಲ್ಲಿ. Exhibit D1 is certified copy. So this is the original sale deed. So D1 ಅವ್ರು ಕೊಡಿ, ನೀವಾಗೇನೆ ಕೊಟ್ಟಿಲ್ಲ ಸರ್? Yes, given original. ಇಲ್ಲಿದೆಯಾ ಪೇಜ್ ನಂಬರ್? Two 1 3 na? One minute. ₹1,000 has been paid by whom? The Ghaffar Khan. Ghaffur Sharif. He is not disputing it. So the question is only whether that Rasul Khan's document which is given to Ghaffur Sharif, whether it is sale deed or mortgage deed. But even in the document produced, which is shown as a sale deed, there's no mention of mortgage and return of the property. Reconveyance mention Madila. That you are also admitting. So the understanding, but that is now denied. Children. You are now, according to it, standing in her name. Her name. No, even if it is standing in her name, the fact remains that you have sold the property to Ghaffur Sharif in 67. But even after 67, you are saying that the property is standing in the name of Rasul or his wife, Rasul Khan, when he died. So avatanka avana ಹೆಸರಲ್ಲೇ ಇತ್ತು ಅದು. What about after his death? Exhibit? ಯಾವ exhibit? Page number? $149 ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
Very actually number it has been good. Now, they not done so. Because it's only nominal state. But you are update code, considering the
That sale deed of 1967 is registered. Hmm.
But given the update code, so considering the revenue data, only it does we need the update code effect.
Ah. Hmm. 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 Correct. Both the courts hold the same thing. Because Exhibit D1. Hmm. See, what is your suit claim prayer? Prayer in the suit. What is a prayer? Owner and melee. You can't go by the revenue entries. No doubt earlier Rasul Khan's prior to that once he enters into a sale deed, which is in the form of sale deed, unless there is a specific provision for reconveyance, it cannot be treated as a mortgage deed because you have not placed anything on record except to say that after the sale deed made in 1967 in favor of Ghaffur Sharif, the mutation or revenue entries are not changed. That is your only contention. All right. If he takes a sale deed, he doesn't change the entry because he has to go and file for khata and change the entry. If he doesn't change, will he not become the owner? There's a presumption that he's the owner. Only the khata entries of the tax revenue entries has to be changed. But merely because the revenue entries are there and you don't have sale deed, you don't become owner. It's on the, both are contrary to each other. So what material you have produced? Nothing. So that's why the trial court as well as first appellate court have appreciated and allowed, dismissed both your suit as well as the appeal. Ten acres. Yeah, that is 67 later. Yes, too. See, 1967 ಅಲ್ಲಿ 1000 rupees ಕೊಟ್ಟಿದ್ದೀರಾ 10 acresಗೆ. ತಗೊಳ್ಳೋರೇ ಇರ್ಲಿಲ್ವಲ್ಲ ಅವಾಗ. ಹೆಂಗಿದೆ? How? This is not your case. What is a ಇದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮಾ. ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ. Exhibit P1 to P13. ಏನದು? What is P1 to P30 is all documents. There is a question of law in this. Question of law, Andre, it has to be question of law which is going to attract, or substantial question of law under section 100. Even evidence can be considered by this court if the trial court as well as first appellate court has ignored a material evidence which is on record, which would be material for discussion of the decision of the suit. Illela consider madre. ಅಷ್ಟೇನಾ? ಆಮೇಲೆ ಏನಾರು ಅಮೆಂಡ್ ಮಾಡಿದ್ರ? ಏನು, what is your last amendment? It's a mortgage.
Let Murat, they don't say the fact. They. Ye dono Murat ke say the only. ಹೀಗೆ ಎರಡು the thousands compared in sections 4 to 22. But an application late after the display the business, although limitation has depends. Light should be clear in a state with the other facts. The thing, they don't say with the other facts and those 80 cars. Actually, they should stay. Yet, paragraph can be looked at any point of time.
ಬಟ್ ಎವಿಡೆನ್ಸ್ ನಿಮ್ದೇನು ಬಂದಿದ್ಯಾ? ಎವಿಡೆನ್ಸ್ ಏನಾರ ಇದೆಯಾ? See, your whole case is 1967 Rasul Khan, which he executed the sale deed, was a nominal one, and it was a reconveyance. Sale deed allantu ಏನು ಬಂದಿಲ್ಲ. ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ were you able to elicit anything with regard to DW1? Dambike? What is Dambike? But has he admitted?
BW4, the relative has been accounted as BW4, TCS property.
So even the relief of injunction is rejected by saying that she is not in possession.
Some of the relevant documents of existence. Initially, what we filed an appeal. We was allowed and matter was
Remanded.
Then we filed an appeal. Before the appeal was allowed and remanded, we got the these are all subsequent polygons.
W3 ಯಾರು? Witness to the sale deed. Attester ಬಡಲ್ರಿ sale deed ಗೆ attester ಬಡ. ತಿಮ್ಮಯ್ಯ.
The explanation he passes, he says, a nominal sale. In terms of dependent from the fourth quarter, the full sale. The contract conditions, yes, another contract, the contract, income.
There is no document for completed prior except oral report. I was present when the transaction under exhibit B was took place. So when the transaction took place, that is not this is nothing described. She was present. So she had the knowledge that this is nothing from it there. I was present when the transaction under exhibit B was took place. The next time reviewing the proper examination in chief is 98. We was also present at the time of the yes,
Page?
Page 98.
I was also present.
I was also present at the time of the executive so he had the knowledge that 1960 the document. So she did appoint 3 years.
But anyway, that is not your plea.
That
That can be looked into till the first appellate court, not now. We are in second appeal.
Here, strategy is the system. He says, what is the big concern? He says, declarate and then he says, it's a market. So many contentions he has taken, it is also different issues. This is the sort of cancellation. Then we declare it as a nominal statement. Then mortgage. Then we are agreed to read
Still, I mean,
which is it? But it is what happened there. The minister deed was one of outright sale. Taken number 43.
Item number 40? 43.
Where the minister deed was one of outright sale for the state. There was no reservation related to reconvey. And there was a minister of say the same day, reclaim the property after 5 years of period. They did not follow the part of and that was not point of part. Here there is no other document there for this. Oral state. Then the figure other issue. He found Karnataka General Election Policies. Again, it is not open to vote on the basis of sentence. Transaction 1 was one of parties. The sentence cannot have any effect on the document. First, the absolute state. Apart from the provision, we had seen that it is eligible in the documents. Because the amount of seeking of the rates concepts, even this, there is no such power sessions study occupied. That they cannot try to treat it as part taking as to essentially build up a critical to recover the money from the capital start existing. Thereby, there will not be a relationship recover to one of the features of the market. Effect of provisional effects. First, you number of you feel like you're not all years of the effect of this. This is the one market when you grow. Clearly, that they were or a total play integration of all the but that was the exact way. Total play integration was where we are entitled to the
That's also not here. Howdo, but PW4 also has said the same thing. PW4 is plaintiff. But even if he doesn't admit, the fact that your exhibit that D1 sale deed does not contain any clause with regard to reconveyance, means it's a sale deed. This also is from Karnataka only. Sure. Worked. Appeal is preferred by the appellant plaintiff. Being aggrieved by the judgment and decree dated 27/1/96, passed by the Civil Judge Junior Division Tiptur in OS number 319 of 1977, wherein the learned civil judge dismissed the suit filed by the plaintiff, aggrieved by which the Civil Judge Senior Division Tiptur in RA number 18 of 1996 dismissed the appeal preferred by the plaintiff and confirmed the order passed by the learned civil judge Junior Division Tiptur. Full stop. Brief facts of the case. Before that, parties herein shall be referred to as per the status before the trial court. It is a case of plaintiff that her husband, by name Rasul Khan, who was the owner in possession and enjoyment of suit scheduled property bearing survey number 12/3 to an extent of 4 acres and 12/4 to an extent of 4 acres, situated at Kodihalli village, Kasaba Hobli, Kittur Taluk, executed a nominal sale deed in favor of No, but you have said 4 + 4 acres. In appeal memo, you said so. ಎಷ್ಟಿದೆ totally? So is there any bifurcation? 12/3 and 12/4 together measuring 10 acres. He executed a nominal sale deed in favor of father of defendant 1 to 4 for a sum of rupees 1,000 under the nominal sale deed dated 3/6/1967 with a condition to reconvey the same after payment of rupees 1,000. Full stop. It is further stated that after the execution of the nominal sale deed, the plaintiff's husband, Sri Rasul Khan, died. And thereafter, the plaintiff discharged the loan amount and requested the defendants to reconvey the sale deed in respect of suit scheduled property to an extent of 10 acres with the Kharab land. But the father of respondents, defendants 1 to 4, did not reconvey the property. Hence, the plaintiff filed the suit seeking for the relief of declaration and consequential relief of injunction. To declare that the sale deed executed by her husband in favor of father of the defendants 1 to 4 on 3/6/1967 for a sale consideration of ₹1,000 is only a nominal sale deed, and further to direct the defendant to reconvey the sale deed in respect of suitural property in favor of the plaintiff. Full stop. On appearance, the defendants filed their statement of objections and denied the contents of the plaintiff in the plaint and totally rejected the claim of the plaintiff with regard to the sale deed of 1967 being a mortgage deed, or that there was any reconveyance between the parties to reconvey the property in favor of plaintiff. The defendant also coupled the plea that the suit is not maintainable and sought for dismissal of the suit. Full stop. Based on the pleadings, the trial court framed relevant issues for consideration, being issue number 1 to 7 and additional issues. Number 1, extract mark issues. Page number 8. In order to substantiate the issues, and establish the case, plaintiff got examined herself as PW. Plaintiff got examined PW1 to PW3. PW4 idara. Plaintiff examined herself as PW4 and her witnesses as PW1 to 3 and got marked exhibit P1 to P30. Whereas the defendant examined one witness as PW1 and got marked exhibit P1 to D2. Correct? Erade alla? P1 and D. After hearing the plaintiff and the defendant and on examining the material documents, both material evidence, both oral and documentary, the trial court dismissed the suit of the plaintiff by its order dated 27/1/1996. By the judgment dated by its judgment dated 27/1/1996. Stop. Aggrieved by the dismissal of the suit, plaintiff preferred first appeal before the civil judge senior division. JMFC and Aduno, are it senior division or before the civil judge senior division and JMFC at Tiptur in RA number 18 of 1996. Full stop. The first appellate court, after hearing the plaintiff and the defendant, and on consideration of the issues framed by the trial court, formulated the following points for consideration. Para number 10 of the first appellate court, 3 points, point 1, 2, and 3. Full stop. After hearing both the plaintiff and the defendant, first appellate court on reappreciation of material evidence, both oral and documentary, and reanalyzing and reappreciating the same, did not find the need to interfere with the judgment passed by the trial court, and there being no material in favor of the plaintiff with regard to the contentions taken by the plaintiff of the mortgage and reconveyance, which is not substantiated by the plaintiff, and there being no material evidence, both oral and documentary, dismissed the appeal and consequently confirmed the judgment and decree passed by the trial court. Full stop. Para. Being aggrieved by the dismissal of the suit and the dismissal of the appeal, thereby confirming the judgment and decree of the trial court in OS number 316, 319 of 1977. The plaintiff has preferred this second appeal, raising certain substantial question of law to be considered by this court. On hearing the plaintiff and the defendant, this court-wide order dated 22/7/2008 formulated the following substantial question of law for consideration in this appeal, within inverted commas, whether in the facts and circumstances of the case, the courts below were justified in dismissing the suit of the plaintiff without considering exhibits P1 to P30 in proper perspective, close inverted commas. It is the vehement contention of learned counsel for the plaintiff that the courts below, that both the courts, the trial court as well as the first appellate court, has not appreciated the documentary evidence, both the documentary evidence, and while passing the impugned orders, have ignored the exhibits and the exhibits P1 to P30 and the evidence adduced by the parties. It is also the contention of learned counsel for the plaintiff that the document executed as a sale deed by the husband of plaintiff, namely Shri Rasul Khan, in favor of the father of defendants 1 to 3, Ghaffar Sharif, was a nominal sale deed for a nominal sale consideration of rupees 1,000, and it was the understanding between both the parties to reconvey the same by receiving the said amount of rupees 1,000 along with interest. Which has been conveniently ignored by the trial court as well as the first appellate court. Full stop. Para. It is also the vehement contention of learned counsel for the plaintiff that pursuant to the sale deed dated 3/6/1967, the revenue entries and the khata continued in the name of the husband or herself. Plaintiff is after the sale deed, the revenue entries contained in the name of whom? In the name of the plaintiff and the property was never transferred in the name of the defendants 1 to 4. Therefore, the ownership of the property was not transferred in the name of the defendants 1 to 4. This aspect also has been ignored by the trial court as well as the first appellate. He further contends that prior to the property standing in the name of plaintiff, the property stood in the name of her husband, despite the sale deed dated 3/6/1967. Full stop. Under these circumstances, learned counsel contends that the document, though styled as sale deed dated 3/6/67, it was in effect a mortgage deed between the husband of plaintiff Rasul Khan in favor of the father of the defendants 1 to 4, namely Gafar Sharif. Both the courts having ignored this aspect and having not considered the same, the substantial question of law arises for consideration with regard to whether the courts below were justified in ignoring the exhibits P1 to P30 and the evidence adduced by PW1 to PW4 in rejecting and dismissing the suit of the plaintiff, in not considering the sale deed, which is disguised in the form of sale deed, to be one of the mortgage deed. And so also the fact that pursuant to the sale deed dated 3/6/1967, the revenue entries, khata and the tax receipts continued in the name of her husband and thereafter in the name of plaintiff. Full stop. On these grounds, learned counsel for the plaintiff contends that the substantial question of law arises. The same will have to be held in favor of the plaintiff, and consequently the suit dismissed by both the courts will have to be reversed and set aside. Full stop. Per contra, learned counsel representing the defendants 1 to 4 vehemently contends that there's absolutely no reason for interference in the judgment and decree passed by the trial court as well as the first appellate court by this court, for the reason that there is no substantial question of law that arises for consideration in this matter. Learned counsel further contends that the sale deed dated 3/6/67, which is marked as exhibit P1 and D1, which is marked as exhibit P1 being the certified copy and the original as D1 produced by the defendants are one and the same. There is absolutely no averment or covenant in the said sale deed with regard to reconveyance or mortgage, and that the entire covenants in the sale deed describe the document to be a sale deed and absolute sale made in favor of the father of defendants 1 to 4 by the husband of plaintiff on 3/6/67. Though the plaintiff has taken the plea that it is a mortgage deed and it is the understanding between the plaintiff and husband and the father of the defendants 1 to 4, nothing is forthcoming in the document exhibit P1 and D1. Hence, when nothing is seen or forthcoming in the document, it cannot be assumed by the plaintiff, defendant, or by the courts what is contrary to the document, because the document would speak for itself. The witnesses may lie, but the documents would not lie. It is also a vehement contention of the learned counsel for the defendant that the plaintiff has deliberately disguised the suit in the form of mortgage deed for the reason that a suit for otherwise filed by the plaintiff or any other relief would be barred by the law of limitation. And so also the present suit filed by the plaintiff would be barred by the law of limitation. Hence, even otherwise, the suit being barred by limitation for the reason that the sale deed is dated 3/6/67 and the suit is filed on 7/10/77 after a period of 10 years, the suit is clearly barred by limitation. Under the circumstances, he contends that there is absolutely no perversity, illegality, or arbitrariness in the judgment and decree passed by the trial court, which is affirmed by the first appellate court. Full stop. He also contends that there is no substantial question of law that arises for consideration in this appeal, because all issues have been decided and the evidence adduced by the parties have been properly appreciated, analyzed, and reappreciated by the first appellate court. Under these circumstances, he seeks for dismissal of the appeal with exemplary cause. Full stop. Para. Admittedly, the suit preferred by the plaintiff is for the relief of declaration to declare the plaintiff to be the owner of the suitable property and to declare the sale deed dated 3/6/1967 to be a mortgage deed, and for the relief of permanent injunction restraining the defendant from interfering with peaceful possession, enjoyment of the suitable property of plaintiff. It is not in dispute that prior to the sale deed, the husband of the plaintiff was the absolute owner of the suitable property. He executed a sale deed dated 3/6/1967 in favor of the father of defendants 1 to 4 by way of a registered sale deed and handed over the possession of the suitable property. In order to decipher as to whether the document is a sale deed or a mortgage deed, the document will speak for itself. Exhibit P1 and D1, which is one and the same, dated 3/6/67, speaks for itself, and there is no ambiguity in the said document to show or prove the fact that it is an absolute sale deed executed by the husband of plaintiff Rasul Khan in favor of the father of defendants 1 to 4. Initially, the suit preferred by the plaintiff came to be dismissed. It was dismissed first. Then a regular appeal came to be filed in RA number 33 of 79. and the first appellate court remanded the case back to the trial court for disposal afresh. Thereafter, the trial court decreed the suit in favor of the plaintiff, which was taken up in appeal by the defendant. And again, the matter came to be remanded, correct? Again, it came to be remanded to the trial court for consideration once again. And after the parties adduced evidence, the trial court, for the second, the trial court thereafter dismissed the suit. And the same was taken up in appeal by the plaintiff in the first appeal, which dismissed the appeal referred by the plaintiff and confirmed the judgment and decree of dismissal of suit passed by the trial court. It could be possible that during this period of a decree having been granted in favor of the plaintiff, the entries in the revenue records were changed in favor of the plaintiff. And that continued till the matter was dismissed by the trial court. By an order dated 27/1/1996. Full stop. Section 100 of the Code of Civil Procedure reads as under. Section 100 of the CPC has got a limited and narrow scope for consideration, as this court cannot venture into reappreciation and reanalyzation of the material evidence, both oral and documentary, after the trial court and the first appellate court has already examined at length in detail of the evidence, both oral and documentary, and the first appellate court having considered the same by reappreciating and reanalyzing the factual aspects of the matter. In second appeal, the limited scope for consideration would only be the substantial question of law that is made out by the plaintiff for consideration. In the present case on hand, the substantial question of law sought to be made by the plaintiff is to the effect that the trial court as well as the first appellate court have not considered the evidence adduced by the parties, plaintiffs PW 1 to 4, and the exhibits at P1 to P30 in the proper manner. Full stop. On perusal of the impugned judgment of the trial court as well as the first appellate court, this court is of the opinion that the trial court has extensively considered the evidentiary matters, both oral and documentary, of the plaintiff and the defendants, adverted to the exhibits P1 to P30 and D1 and D2. So also the evidence of PW 1 to 4 and DW 1. And on reappreciation and reanalyzation of the entire material evidence, both oral and documentary, the first appellate court has come to the conclusion that the judgment and decree passed by the trial court is correct, there being no flaw, would not call for interference. And having reappreciated the entire material on record, dismissed the appeal and confirmed the judgment and decree passed by the trial court. The only point for consideration before this court is whether both the courts have taken into consideration the material evidence of witnesses and considered the exhibits P1 to P30. Full stop. I do not find any lacuna or material irregularity in the judgment rendered by both the courts in non-considering the evidentiary material, both oral and documentary, by the trial court as well as the first appellate court. It is a fundamental rule of law in civil jurisprudence that in second appeal, the factual aspects are not considered. It is the first appellate court, which is the last court for consideration of the factual aspect of the matter. And if both the courts have not adverted to the material evidence which are placed on record and causing miscarriage of justice, only in such circumstances the second appeal court will interfere in the evidence not being considered by the first appellate court, trial court and the first appellate court. In the present case on hand, no such thing having been pointed out, though it is claimed by the learned counsel for the plaintiff that the evidence is not being considered by the trial court as well as the first appellate court. On perusal of the original records and the evidence adduced by the parties, this court is of the opinion that the evidentiary matters, both oral and documentary, have been elaborately considered by the trial court, reanalyzed and reappreciated by the first appellate court, and the issue of whether the exhibit P1 and D1 is a mortgage or a sale deed has already been considered by the trial court and the first appellate court, which does not call for interference by this court. In view of the discussions that are made here and above, this court is of the opinion that the substantial question of law framed herein by this court would not inure to the benefit of the plaintiff, as the plaintiff has not made out any reason to interfere with the well-reasoned judgment of the trial court as well as the first appellate court. Accordingly, the substantial question of law is answered against the plaintiff and in favor of the defendants 1 to 4. Accordingly, I pass the following order. The appeal preferred by the appellant is dismissed. Question of law is answered accordingly. Substantial question of law is answered. What is the year? 2007. When is the question of law framed? 2008 ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬೇಕಾಗೈತಿ. ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ನೀವು? 13 years. In fact, there was no need for formulation of question of law. Yes. Next. But you have done your best, what you can do. ಅಲ್ಲಿ ಏನಿದೆ ಅದನ್ನೇ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ಅವ್ರದ್ದು ರೆಡಿ ಇರ್ತಲ್ಲ. Choose this matter 47. 47. Into 45. ಬಂದಿಲ್ವಾ ಅವರು? ಇವಾಗ ಬಂದ್ರ ಇಲ್ವಾ? ಬಂದಿಲ್ವಾ? You can start. Let me hear what you are. Yes, briefly you can say. ಇನ್ನೊಂದು book ಕೊಡಿ. Yes. The divergent opinion is. Now, who are you? Two and you both are purchasers. In whose favor? Who's your vendor? I want to know who's the plaintiff. So one of the ancestors is one of the vendors.
Because one of the ancestors is the original.
Correct. Your vendor. Propositors. The first. See, Timana son of Kadaya.
Dating of the 1953, pertains to survey number 190 of near activity.
Measuring.
Measures 4 acres
Originally.
Just tell me, of 1923, father of the plaintiff, Chikkan, who is the brother of Iman. After this sale was executed in favor of the purchaser is the company. After 1923, the next document in the order of chronology comes a partition deed, a registered partition deed of the year 1947. This partition deed is between the daughters of Puttan and his brothers. There are several properties which have been divided, which includes the property with survey number 190. But by the time it is 1947, property has been coded, and survey number 190 is now referred to as survey number 190 parts.
So it is OD'd into four parts have been made.
190 part 4 is the first have been, right? When I take the partition deed, two portions have been made. at that point. One portion is assigned to the daughters, one portion is assigned to the brothers. 2 acres 5 quintas is assigned to one portion. 1 acre lot has been assigned. Plus in their 1961, the brothers, they execute a registered state deed in favor of one Siddhappa, selling the first portion of 2 acres 5 quintas of land. So in 1961,
Which came to their share.
they come to their share. But there's one other statement that is closest. Subsequently, one more the properties which came to the share of daughters sold in favor of one.
So the daughters also sell.
They also said, they also go to the doctor. But under the date of the 1925. Apart from Sakam, if you look at Rajappa, Malunarka, and Vilmayappa, there are 4 persons to purchase all
From the daughters.
from the brothers. I'm sorry, I have. I have Mr. They purchase.
Brothers you purchase. What is the extent you purchase? Together. 10.5 each. 1 acre well, I tell.
Exactly, it matches the.
So you purchased how much?
I purchased 10.5.
That's all. What about him?
I have purchased. His son, he told not to make a wedding in the year 1990. And purchased from one of the Sana's son. Who's the first different? The one line is the property in 1953.
Yes.
These are the registered. Partition was between the sons of family. They said that 3 brothers were there. Malan, Viyappa, Chikana, and so that party, Viyappa was already because this year and he was no longer part of Malana and Major Viyappa started out there. Yes. They did not. The finished produced product, under which the plaintiff claim, but the plaintiff claims titled on a total extent of 3 acres, 11 homes, with survey number 195.
ನಿಮ್ಮ ಹತ್ರ ಎಷ್ಟು ಬರುತ್ತೆ 2 acres? ನಿಮ್ಮ ಹತ್ರ?
Other 3 purchases also have. They raised by stating that it only has to cover, they do not make it.
What is the suit for?
Declaration. Firstly, It was a declaration that the plaintiff along with dependent number is Malad. They are international property as they not Hindu family property.
Has he contested?
Dependent number eight does not contest.
No, he's not filed statement.
Does not, but only dependent number.
But he is a filed wakalat.
Believe so.
We 217. We have contested.
217 and then need 2. How 7 purchasers? Why I asked is he has filed against you and the others. The others are his family members.
Dependent number 4, 5, 6.
Right. But now defendant number 9, yaar ಹೇಳಿದ್ದು ನೀವು? Mallana. He has not contested. He is the one who has to say whether it is his joint family property. He has not come before the court. No statement filed.
Second one, for example, where the second clear is one. Dependent status. No matter what, right? Thank you. After the favor of second dependent, the revenue increase was what?
Which is made in your name.
For decree that was not dependent on the position of the property.
In 10 guntas. 10 guntas would be about 10,000 square feet. More than 10,000 square feet.
It is more than
How much is 1 gunta? Huh? 1089 square feet, I think, if I'm not mistaken. Okay. Where is this located? Delhi. Chikmagalur, not in Bangalore. All right. What has happened to the suit? It's dismissed.
For multiple reasons. First, while answering the issues which were framed, the first issue, the issue of limitation was taken up for a particular reason. Let's say 1984, this plaintiff files a suit for permanent injunction as against the current defendant number 4, 5, and 6 only.
Your vendors.
Not my vendors. Also, none of those defendants take title or possession of the property.
It's only for permanent injunction.
Only for permanent injunction. That written statement, they make a statement very clearly that this property, 2 units, was purchased by Siddhartha in the year 1961, and also that 10.5 acres of land has been purchased by me.
What happened to that suit?
Who came to be
in favor of the plaintiff?
in favor of the plaintiff? The dependent number sound is not a part. Dependent number 1.
So plaintiff got permanent injunction.
Not against me.
Not against you, but they got permanent. But no other relief was sought.
Despite the fact that his title was denied. Despite the fact that the title was denied.
What are the other issues?
The other issues, I just
read the issue. Read the issues.
issue number one is whether plaintiffs who discuss the problem, discuss the question, whether the plaintiff who said and depend upon the date of the ownership of property. Whether plaintiffs who is entitled for possession of property. Four, whether plaintiffs who is entitled to leave profits. Whether the suit is barred by time. Whether the court has no legally refused. Whether the suit is bad for non-joiner use. By answering those issues number 1, 2, 3, and 4. It was sought to be proved by the plaintiff. They were all. So far as issue number 5 with regard to limitation, that was answered. What part I give it. Issue number 7 was also answered against the plaintiff. Stating that the suit was bad for non-joiner. There was a statement made pointing out that as per the stated towards Kerala of supply was purchased not just by me, it was purchased by 3 others. The 1975 night, when I did not purchase.
The suit came to be dismissed.
The suit came to be.
First appellate court allows it. In the original suit earlier filed by the plaintiff, very same plaintiff. You both of you are not parties. But by the defendants, did he say that you have purchased it?
No.
No, you just said.
No, he doesn't say I purchased it from independents. Not he said they are not principals.
Oh.
The plaintiff says you are reporting to the court that they are not.
ಅದನ್ನೇ ಮಾತ್ರ ಹೇಳ್ತಾ ಇರೋದು. In the suit filed by earlier suit filed for permanent injunction by the very same plaintiff, the defense taken by the defendant therein was that he is not the owner.
Yes.
And your vendors are the owners of the property. And the plaintiff does not. What he should have done? Which of the whole provision is there?
Considered by the as non-general was also reported as he did not have others. I did not, my vendor was did not take any time. I did not take anything, but without going against others, who according to him also did not sustain. Yes, once again given up the plea that it is not actually happening in the right place. But other aspect was that it is fine. I mentioned that in the 1975.
So consequently, in the present suit, has he sought for cancellation of the sale deed by your previous vendor? No, neither his. So your deed has been now cancelled. What about your vendor then? What about your vendor? Because if your sale deed, if the court holds that you did not get title, your title will go. But what about your vendor?
My vendor's title or vendor's title goes only then my title goes.
That he has not asked for. So what is now set aside is only that you don't get title. When your vendor's title is undisturbed. No declaration also.
Claims that there was a partition. He produced that partition. But in that partition page, 190/4, but it says it's only 1 acre. But suit is filed as regards 3 acres 11.
according to the plaintiff, there was a partition which is, it was specifically needed.
What is on ground? What is on ground?
There are portions of property like scattered, but not the road, the other property. That is what the property.
Who's in possession of your property? So also you. What are you doing there? All right. Who's the other side? Rajendra. Huh? MS Rajendra. All right, you can continue some other day. You're Mr. Rudraya? Jay. For Rudraya. You have Wakalat? Doesn't matter. Learned Counsel Sri Ajay, representing Mr. Rudraya, M. Rudraya for appellant in RSA 699 of 2007, is present. Has addressed arguments briefly. So also Learned Counsel Shri Syed Akbar on behalf of Mahantesh S. Hosmat in RSA 1243 of 2007. There is no representation on behalf of respondent. In order to facilitate the respondent's presence, release this matter on. And do you want? Stay there. All right, put 31st Akim. Today is 29th. First Akim, first September. No. Eventually it will come up to 2:30 only. This can be posted this way, 2:30. Jayashri then appears for the appellant or the respondent. Released next week. Shivkumar, ready illa. ಬಂದಿದ್ರಾ ನಿಮ್ ಸೀನಿಯರ್ ನೋಡಿಲ್ವಲ್ಲಪ್ಪ ನಾವು ಒಬ್ಬ ಕೂತಿದ್ರಲ್ಲ ಇಲ್ಲ due to paucity of time release this matter next week. Counsel for appellant is present. No representation on behalf of respondents. Agaraj, you appellant, huh? Counsel for appellant is present. No representation for respondent. Release next week. Narayan Reddy then appears. Release next week. The correspondent. No representation on behalf of appellant. Counsel for 1 and 2 is present. Due to paucity of time, release next week. Next week. No representation on either side. Release next week. Smell. Idara Prasanna Shetty. Who's the other respondent? You are for respondent. You are ready? All right. Both the learned counsel for appellant and respondent are present. Due to paucity of time, released next week. All right. Tuesday nekodi avrige. Next. 5th. Come out there. Today we have one disposal. Huh? Yes, madam. ಇವತ್ತಿದೆಯಾ ನಂಬರ್ ಏನು ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಮ್ಮ 56 ಏನಾಗ್ಬೇಕು ರಿಸೀವ್ಡ್ ಬೈ ADLR ಬಂದಿದೆಯಲ್ಲ ಬಂದಿದೆ ಅಲ್ಲ ಇಟ್ ಇಸ್ ಅರ್ಜೆಂಟ್ ಟೈಮ್ ಆಗಿ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ just have a look at that report.